Yes. Yesterday we woke up to a very disturbing trending video on our Facebook, particularly with regards to one Mrs. Comfort Bob and Ibom airline. We saw where she was being dragged down, exposed, and beaten. Subsequently, he was being arraigned and charged to court for assault, conspiracy, and what have you, on 4 count charge. To my mind, though what she did, I'm not saying what she did was right, but there are procedures, there are processes. Our legal system provides for ways and means of where a party who is actually at fault could be properly arraigned before a court of law in Nigeria. Now, with due respect to the Magistrate Court of Ikeja, the whole proceedings with regards to the arraignment and remand is to me was unlawful, was illegal. The courts with regards to hearing that matter ordinarily is the Federal High Court of Nigeria. Now let me explain. Section 15 sub 15 of the ACGL provides thus. It said, where a suspect is arrested with or without a warrant and volunteers to make a confessional statement, the police officer shall ensure that the making and taking of that statement shall be in writing and shall be recorded electronically on a reachable video, compact disc, or any audio-visual means or whatsoever. I'm not sure there was something of this nature regarding the speedy way the lady was being remanded. Now let's look at section 17 sub 1 and 2 of the same law. Let me read. It says, where a suspect is arrested on allegation of having committed an offense, a statement shall be taken if he so wishes to make a statement. Sub 2 states thus. It says, short statements may, where the suspect so elects, be taken in the presence of a legal practitioner of his choice, or where he has no legal practitioner of his choice, in the presence of an officer of the Legal Aid Council of Nigeria, or an official of the Civil Society Organization of Nigeria, or Justice of Peace. Now, I don't see this law being applicable because we look at the manner in which he was being arraigned and remanded. I'm not sure these procedures were followed. Now, the major section of the law that this whole shenanigans occurred is section 251 of sub 1 of the Constitution that provides. It says, let me read section 251 sub 1 first. It says, notwithstanding anything to the contrary contained in this Constitution, and in addition to such other jurisdictions may be conferred upon by an act of the National Assembly, the Federal High Court shall have an exercise jurisdiction in the exclusion of any other courts in civil causes and matters whatsoever. Now, sub K now says thus. It says, aviation and safety of aircraft. The whole shenanigans regarding the dragging of the woman happens in an airport and in an air flight. And the right court to hear and determine that suit is the Federal High Court of the Federal Court of Nigeria. The Federal High Court of Nigeria has the right to hear this, so not the Magistrate Court. The manner where the lady was being arraigned is actually to me it's null and void ab initio because it is clearly an abuse of court processes. The court vested with power to hear the suit is the Federal High Court of Nigeria, not Magistrate Court. With due respect to the Federal High Court, the 4-count charge being arraigned against her is null and void. Now, the only recommendation I would recommend is that 1, the lady can file a preliminary objection, telling the Magistrate Court to hear that suit, being that the whole suit was commenced unlawfully and illegally. That's 1. And then 2, where the court insists on going on the matter, the defendant can, on appeal, overturn the judgment of the court on the grounds that the court never had jurisdiction to hear the suit. So the law is clear on how a manner and way a suspect could be arraigned. Section 251 sub K provides for a manner and way a suspect who is arraigned unlawfully can seek justice regarding this matter. So section 251 sub K of the Constitution provides that where a matter involves aviation matters and safety, the word section sub K, I emphasize, sub K 251 provides for aviation and safety of aircraft. Where there is a deviation of this act from this section, it makes everything null and void ab initio with regard to section 251 sub K of the Constitution of the Federal Republic of Nigeria. So the whole 4-count charge conferred against the said defendant, to me, is ab initio null and void. And the right court to hear the suit is the Federal High Court of Nigeria. Every other court besides this one is null and void.